Well, good afternoon, everybody. Welcome to this webinar on mortgage lending requirements for conveyancers. I'm Ali Parsons. I'm from Landmark Information Group. I'm customer success consultant with Landmark and have been for the last 3 years and in a total of 14 years with Landmark. Hopefully, most of you know who Landmark Information are. We're providers of the environmental reports, data and analysis that go across lots of different styles of reports for the legal sector. But we don't just look after the legal, we also look after solicitors, architects, estate agents, and even lenders with data that helps them provide information for their clients. Now I'm just going to try and get my notes up because I was going to introduce my hosts. Now I'm struggling to see them, so I do apologise. No.
Do you want us to introduce ourselves?
I will do, yeah, if that's okay. So I'm really sorry, I had it paused here and now I can't see it. I'm just going on our lovely okay, I've got it here now. Okay, so today's session is presented by Fiona Haggart. Fiona is a chartered surveyor with a long history in the banking industry. She's been at Barclays for 4 years and having previously spent time as Director of Valuation at the Royal Institution of Chartered Surveyors. With her is Chris Shute. Chris is an Australian qualified lawyer with over 10 years experience in financial services regulation and mortgages, and he joined Barclays in the secure regulated lending team in January 2019. This is one session of a variety of webinars available free of charge to the Surrey Law Society members. But before I hand over to Fiona and Chris, just a few housekeeping rules to cover, and you would have seen those on the screen. So if you have a question that you'd like to ask one of the speakers during the webinar, you can ask this by using the Q&A facility within Zoom. Hopefully you'll navigate it a little bit better than I did. If you'd like to speak to Fiona and Chris at the end of the session, then you can request this by using the raise hand function. As you will see, the webinar will be recorded and made available to members after the event. So, as I say, Landmark, very proud to be a sponsor of and supporter of Surrey Law Society and the sponsor of today's session. So without further ado, I'm going to hand over to Fiona.
I think I might start actually, Fiona.
Really well,
no worries.
No
worries. I'm just going to share my screen. So I can see on the call, we haven't got a huge audience today. So I'm quite happy sort of to keep this informal, keep it consultative. I think if people have questions and comments as they go along, please just interject and say something, because I must admit, designing this presentation, being a lawyer working for Barclays, I'm a little bit disconnected from the action. I do get involved with the lender's handbook from time to time in our requirements, but it tends to be when things have gone a little bit wrong or in rarer situations. So if anybody wants to talk or has any questions, please just go ahead and do so. Can everybody see those slides okay? Does that look okay? Cool. Someone say yes if they're not on mute.
Yeah, they've come through fine.
Okay, perfect. Thank you. So I'm just going to start by talking about our panel arrangement. So we currently have 6,632 active panel firms on our panel. There will be some cases of firm being represented more than once on this list just because firms have multiple offices. There's a requirement to be signed up for Lender Exchange, and you apply to be a member of the Barclays panel through Lender Exchange. And so if you're not a member of Lender Exchange already, you need to become one in order to be on our panel. The decision to appoint a panel firm sits ultimately with Barclays. Once the application is made through Lender Exchange, it's sent to us for our consideration. We will do searches on it and we'll find some details of SRA alerts and media checks. We receive about 4 to 5 applications per week for new panel firms. If we encounter anything that's outstanding, you know, such as there being perhaps an adverse finding against the director of the firm or something like that, we will liaise with the firm to work through that issue and decide whether we can appoint them to the panel. And then once that's happened, the panel management team will work to physically input the details into our system. Panel firms are allocated a panel number, which should be quoted on communications. And then once that firm has been onboarded onto our system and through lender exchange, we'll receive alerts for the change of address, change of office, new directors and SRA alerts so that we can monitor whether it's appropriate for that firm to stay on our panel for the future. Firms will be removed from the panel if Barclays is notified by lender exchange that the firm is closing or if lender exchange fees are not paid. So that requirement to be a member of lender exchange is a relatively new one. I think that came in last year, if not the year before. Once you're admitted onto the panel, it's a requirement to comply with the Barclays panel terms and conditions. Under those terms and conditions, firms are responsible for certain things, such as the reconstitution of title deeds. And if there is a request for made by Barclays, the firm needs to forward the title deeds and documents to another firm within 7 days, if instructed to do so. So what I'm doing now is just basically going through some of the basic requirements of those terms and conditions because they're quite important. From time to time, we do encounter issues with them. Files must be retained for a minimum 6 years from the date of the mortgage. That's quite important because obviously if something goes wrong, we might need to call on our panel firms to provide files for us. Firms must carry out instructions with reasonable care and skill, ensuring all employees are qualified and competent to do so and have been suitably screened prior to being engaged. It's a requirement to reply promptly to correspondence from Barclays and lender exchange and to keep these parties advised of any delay or difficulty in carry out requests. And it's also a requirement to notify lender exchange if any personnel are changed or convicted of any offence involving fraud or dishonesty, or if there's any if there's a customer that may be acting fraudulently or dishonestly, subject to SRA rules around reporting those. If there's bankruptcy or insolvency of the firm or any people involved in the firm, change in control or any disciplinary action against itself or any personnel. So it's important that Barclays is kept up to date on those matters. If Barclays is notified that there are, adverse findings or there are conditions added onto a solicitor's license, we are able to request undertakings that that individual will not sign certificate of titles on our behalf. Just some additional points on the terms and conditions. It's a requirement to keep all information that the firm obtains in dealing with us relating to our administrative, financial, technical, marketing, operational arrangements and business strategy confidential. We do review the terms and conditions from time to time. So while I've been in the team, we've done that 2 or 3 times. A recent change we made was that we used to have a requirement for firms to have at least 2 members. So that requirement has changed. And if we do change the terms and conditions, we'll vary them and let you know. A practice is able to terminate under the terms and conditions with 14 days notice. And Barclays is able to terminate at any time. And there are some trigger events which result in automatic termination, such as any member of the practice being charged with a criminal offence other than one under the Road Traffic Act. And normally we have obviously come across situations where we've had to terminate panel firms' appointments before. When that does happen, it is expected that that firm will continue to act on any deals ongoing, subject to there being a decision by Barclays for that file to move over to another firm. But regularly, it's usually that the firm will continue acting unless something very serious has happened. So that's a summary of how our terms and conditions work and what we need for our panel firms to do to be able to sign up, the key thing being a member of lender exchange. And now I'll just talk through the UKF Lenders Handbook. So we'll start by looking at part 1, which is obviously the requirements for all lenders, and then recap of part 2, so the Barclays specific requirements. We're not going to cover everything in this session because there's obviously quite a lot in the Lenders Handbook, but I thought it might be useful just to cover those key provisions, and then maybe if anyone wants to comment about any pain points or any requirements that they have, then I'd be happy to take questions and comments on those. The Lenders Handbook hasn't been updated for quite a while in terms of having sort of a wholesale review. And this is something that UKF have noted, and a working group's actually been established with some major lenders to look at rewriting it as well, because it might, I'm not sure what it might be from your experience, but we can at least see that there are probably some changes that should be made. A really basic thing is that some of the references to the SRA code of conduct and the rules are a little bit out of date. So it will be good to see what comes of that, but I'll talk a little bit more about that after we've recapped part 1 and part 2. Very quickly, made up of part 1, part 2, and part 3. Part 3 is only relevant when you're representing the lender only and not doing dual representation, which is how most mortgage deals work. So we're just going to cover off parts 1 and part 2 today. So when you're instructed to act for Barclays, you will receive an instruction letter, and that instruction letter will specify whether you're being instructed to act in accordance with the lender's handbook. And if you are instructed in accordance with that, obviously there's an expectation that you'll act in accordance with the lender's handbook. 1.4 standard of care. This is quite important to understand what we expect of our panel solicitors. So you need to be reasonably competent solicitor or licensed conveyancer acting on behalf of the mortgagee. For any transaction during the lifetime of the mortgage, you must use our standard documents in all cases and must not amend or generate them without our written consent. Barclays will provide all documents to panel firms. It's really important that any part of the acting for Barclays is not subcontracted out or assigned to any other person. We expect it to be done by the panel firm. And then these rules around 113, 114, and 115 are about conflict of interest. So it's quite important that you remember this. We'll talk a little bit about dual representation of conflict of interest a little bit later on. So you must not act for us if the borrower is a member of your immediate family and you are the sole practitioner. A firm must not act for us if the partner or fee earner dealing with the transaction or a member of his immediate family is the seller. That's really important. Obviously, the seller's got a real interest in getting the deal done, and so we don't accept that as something that can happen. And the firm must not act for us if the partner or fee earner dealing with the transaction or a member of his immediate family is the borrower unless satisfied there is no conflict of interest. So we'll pick up on that concept of a conflict of interest a little bit later on. There are specific requirements around communicating with Barclays in 2.3, including reporting about matters, reporting certain matters to Barclays, and this is sort of when you're undertaking the actual due diligence of the property, and then identifying the handbook provision and the extent to which the issue is not covered by it. Under that 2.3, we basically expect our panel firms to identify the issue, identify the part of the handbook that might not be covered by it, and then give us a summary of the legal risk and a recommendation on how to proceed. So that's quite important for us to understand when we're deciding whether we should lend. Under 3, there's a requirement to follow professional body rules in respect of money laundering regulations and the Proceeds of Crime Act, and to verify the details of the representative of the seller if you're not familiar with them, and then to obtain evidence of identity of the borrower, and there's a list of acceptable documents in Part B. This is something which is potentially being looked at as part of the rewrite or the working group which is being set up for the UKF Lenders Handbook. Under 4, you need to take reasonable steps to verify that there are no discrepancies between the description of the property as valued and the title and other documents. If there is a discrepancy, you need to tell us immediately, and also take reasonable steps to verify the assumptions stated by the valuer about the title, such as tenures and easements. We recommend that you advise the borrower that there may be defects in the property which are not revealed by the inspection carried out by our valuer. And when the mortgage officer states that a final inspection is needed, you must ask for the final inspection at least 10 working days before the advance is required. Fiona, I think, has this provision ever...
to jump in.
Yeah, well, I was thinking, because I know that I have encountered situations before where we've sort of had a valuation. I think the issue's been perhaps flagged in the valuation, but then it hasn't become apparent to Barclays some time after that. So did you have anything to add here about how that happens?
Yeah, I mean, it's really critical that any of these issues are raised as early as possible in the process. We make mistakes, and things get lost. Obviously not very often, but also it takes time to refer back to the valuer and to get an answer, and if there's any other issues around it, it gives us time to deal with it. So I've actually got one of these ongoing today where a conveyancer has come to us with a challenge. The surveyor's said we shouldn't be lending. I'm looking at it, I'm discussing it with the surveyor. We need time to go through that process, and the earlier the notice we get, the better. it's a real problem for us when these drop on our laps, so to speak, literally just as the property's about to complete, and it happens. Sometimes it's our fault, sometimes it's the conveyancer, but it's critical, absolutely critical, that we can get to the bottom of these and serve the customer in the best possible way at the earliest stage.
I can remember an example recently, I think, Fiona, where I think it was actually not the solicitor's issue in this case. It might have been something that happened at our end recently, where I think there was a property valued. It came back with perhaps a zero valuation or a low valuation because I think the property had been gutted or something like that, and that hadn't become apparent to us just before, until sort of later on in the process, perhaps, you know, a few days before we were supposed to fund. So, I mean, the point is there, if the sooner we know about it, it's much easier for us to do something about it. And the value of the property is very key to us making our lending decisions. So
yeah, I mean, we've got two gateways effectively to identify these issues. One is the valuer, who goes out, or may go out to the property, may not. And the other is the conveyancer. Where both of those gateways fail, we hit a problem, sometimes at the last minute. So it's really key. And in that case, the valuer probably shouldn't have valued it. It was probably outside our lending appetite. But, you know, these things need raising early on and dealing with. Yeah.
Yeah, perfect. Just moving on, so under 5.3.1, if any matter comes to your attention which should reasonably expect us to consider important deciding whether or not to lend to the borrower, such as whether the borrower has given misleading information to us or the information which you might reasonably expect to have been given to us is no longer true, and you are unable to disclose that information to us because of a conflict of interest, you must cease to act for us and return our instructions stating that a conflict of interest has arisen. You must ensure that all usual and necessary searches and inquiries are being carried out, and you must report any adverse entry to Barclays, but we do not want to be sent the search itself. You must ensure that any other searches which may be appropriate to the particular property take into account its locality and other features are carried out. All searches except where there is a priority period must be no more than 6 months old at completion. And you must advise us of any contaminated land entries revealed in the local authority search. Any intrusive or investigative reports should be referred to Barclays. Fiona, is this something that we encounter many issues with, particularly around contaminated land entries? Or
we ask the surveyors not to call for contaminated land reports. We're reliant on the conveyancer to raise that as an issue. It's not something that crosses my desk generally or causes a problem. Most surveyors are aware of where there's a challenge. Maybe Japanese knotweed, if you want to classify that in the same box. That's probably the land issue that crops up most often.
Okay. We don't lend if there's Japanese knotweed, do we?
Oh, we might. Sort of depends on the circumstances. Depends if it's been treated, but we need to know about it. And depends where the Japanese knotweed is. And our policy has recently changed around Japanese knotweed to align with the change in the RICS requirements. So it's become a lot less strict. So if Japanese knotweed is on the site, we may still lend if it's not impacting the property in any big way. Yeah.
Okay, cool. Under 5.5.1, you must, by making appropriate searches and inquiries, take all reasonable steps to ensure the property has the benefit of any necessary planning consents, including listed building consent and building regulation approval for its construction and any subsequent change to the property and its current use. And ensure that there is no evidence of any breach of the conditions of that or any other consent or certificate affecting the property, and that no matter is revealed which would preclude the property from being used as a residential property, or that the property may be subject to enforcement action. If there is evidence of such breach or matter, but in your professional judgment there is no reasonable prospect of enforcement action, and following reasonable inquiries you are satisfied that title is good and marketable, and you can provide an unqualified certificate of title, we will not insist on indemnity assurance and you may proceed. Under 5.5.2, if there is any such evidence and all outstanding conditions will not be satisfied by completion, when you are not able to provide an unqualified certificate of title, you should report this back to us in accordance with 2.3. So just remember that that's the provision under which our expectations around legal risk and the matter that you've come up with is flagged to us. Under 5.6.1, so talking about what we expect for the certificate of, or for the title for the property, the title to the property must be good and marketable, free of any restrictions, covenants, easements, charges, or encumbrances, which at the time of completion might reasonably be expected to materially adversely affect the value of the property or its future marketability, but excluding any matters covered by indemnity insurance. Sorry, Fiona, did you
Yeah, I
want
was just going to say this is one that does crop up a lot.
Okay.
And is often a blocker right at the end. So again, back to the raise it as quickly as possible, please, because this one has an impact on the value of the property potentially, and we need to understand that very early on.
What's an example of something that might be on title, Fiona, that we see at the last minute?
You
Is
might
it
have
like, can it be an easement, or?
It might be an agricultural restriction, or it might be a restriction on resale of the property, who can buy the property. And that doesn't mean that we won't lend on it, because we have rules around, as you're aware, we have rules around what we will accept, and if it covers us adequately as lenders in possession, then we're fine. But we need to be aware of it because it can be a value impactor.
Yeah, I've seen this before as well, where we'll become aware of something at the last minute, and then we sort of have to backtrack on the customer a little bit, which can be a bit tricky. So
there's nothing worse than pulling an offer very late on. It's not good for us. It's not good for the customer. Yeah.
Yeah, no, and it's something we have to give legal advice on as well. So, just to echo Fiona's comments on that, I mean, if something comes up, please just let us know as soon as possible, because, quite often it might be possible under our lending policy, or it might be possible to remove whatever easement is on that title. But if we can do that sooner rather than later, that's obviously a good thing. There are specific requirements for title around leasehold, flying freehold. Freehold flats, I don't think we lend against. Is that right, Fiona? I think that might be
we'll
in our
lend
lending
in Scotland,
policy,
where I guess in theory they're freehold flats. But yeah, we don't lend on freehold flats. But flying freehold comes in many different forms, and needs a review. If it's just a standard flying freehold, as in it's over an archway in a Victorian terrace, it's not a problem. It's absolutely not a problem.
There's a lending requirement. Is it 15% or something?
I think it's 15% off the top of my head,
right.
of the property. If there's more than that, then we won't. And of course, I don't know whether this is a legal term, but submerged freeholds, similarly, where you're underneath and somebody else is on top.
Yes, I guess that's so. The handbook doesn't specifically mention, but I guess it's similar to flying freehold in some ways, although the risk associated with it might be a bit different if it's underground rather than on top. So
can be a challenge, and it needs pointing out.
Yeah, fantastic. Under 5.10.1, you must check whether there are any material restrictions on the occupation of the property as a private residence, or as specified by us, for example, because of the occupier's employment, age, or income, or any material restrictions on its use. If there are any restrictions, you must report details to us, including when the permitted use of the property is not wholly residential. We may accept a restriction, particularly if this relates to sheltered housing or to first-time buyers. Fiona, do we see many examples of this sort of being an issue, or?
It's less of an issue, because I think that those parties that put the restrictions on the properties are fully aware of lender requirements, and it goes back again to what's in place to cover us should we, heaven forbid, be a lender in possession. But yeah, sheltered housing, well, we certainly don't, we as a lender don't lend on over 55 type housing, senior housing. Other lenders do, and we don't. So again, that needs picking out. Hopefully it would emerge at valuation. But as I say, we've got these two stages where we can pick these up, and hopefully if one fails, the other one picks it up.
Fantastic. You must inquire whether the property has been built, altered, or is currently used in breach of a restrictive covenant. We rely on you to check that the covenant is not enforceable. If you're unable to provide an unqualified certificate of title as a result of the risk of enforceability, you must ensure, subject to the paragraph below, that indemnity insurance is in place at the completion of our mortgage. If there is evidence of a breach and following reasonable inquiries, you are satisfied that title is good and marketable, you can provide an unqualified certificate of title, and the breach is continued for more than 20 years without challenge, then we will not insist on indemnity insurance. It's just important to remember around restrictive covenants.
That's quite a common one, actually. Yeah.
Is it?
Yeah.
Okay.
Yeah,
where have you seen that one?
It's rather than breaches. It's where there's a title. Usually access roads, access to the property.
Yes. Okay.
Garden. That's not an uncommon one. And again, hopefully most times it can be got around and we can proceed with lending, but we need to decide whether there's a big material impact on the property.
Yeah, and I think particularly probably with some more rural properties, this 20 years is probably quite a lot of them which have persisted more than 20 years, I would say. So
yeah, but actually, yes, it might have been persisted for more than 20 years, but can you evidence it if the current occupiers have been in there a couple of years?
Good point. Yeah,
Yeah.
it can be challenging. So yeah, cool. Moving on now, so 5.12.1, on completion, we require a fully enforceable first charge by way of legal mortgage over the property executed by all borrowers of the legal estate. This is probably the most important thing for me from a legal perspective. All of our lending needs to be backed up by a first charge. And so it's incredibly important, obviously, that is done, and that when you're acting for us, we make sure that first charge is registered over that property. All existing charges must be redeemed on or before completion, unless we agree that any existing charge may be postponed to rank after our mortgage. Our standard deed of form or postponement must be used. So in that case, yes, we do allow some second charges, but they always need to rank behind ours. So it's always an insistence that we have a first ranking charge.
Pretty standard.
You must ask
big lenders, I should imagine.
Yeah, exactly. Yeah, and it's not something I've encountered a lot of issues with. We did have a bit of a problem during COVID where there was a backlog of registrations, but I think that's mostly cleared by now. But that was due to processing issues with the land registry rather than anything else. So
yeah.
You must ask the borrower how the balance of the purchase price is being provided. If you become aware that the borrower is not providing the balance of the purchase price from his own funds or is proposing to give a second charge over the property, you must report this to us if the borrower agrees. Failing which, you must return our instructions and explain that you're unable to continue to act for us as there is a conflict of interest. You should also have regards to 6.3.1 with any regards to any implications on the purchase price. There are a number of sort of very, once again, specific requirements for leasehold land, which are covered off in 5.14, such as checking that insurance and repair and maintenance of common property is the responsibility of the landlord, and checking only an original or certified copy of the lease, and notification to us if the landlord is absent or insolvent. I'm not going to go into those today because there's a lot of different requirements under leasehold, which can be read quite simply under the handbook. Fiona, did you have anything that you wanted to add on
only that I think
though?
issues around leasehold are likely to only increase with leasehold reform, particularly around
That's a good point.
ownership, absent landlords. So I think we need to be very aware that these challenges are going to be on the increase as we go forward.
And is there a specific part of leasehold reform that you think will result in perhaps more action in that area? Or
well, leasehold reform now doesn't allow a new lease to be granted with ground rent, and the ground rent is the value for the freeholder. So if there's no ground rent, they're less attractive, and the worry is that either the freeholder doesn't see the property as a good investment and won't buy, and therefore we end up with much more common hold, and common hold in itself is not such a big issue, but the concern with common hold is that it's less likely to be put in the hands of a professional managing agent and managed effectively. So with common hold properties, if you've got the occupiers clubbing together to form a committee to manage the building, that's fine if it works.
Okay.
Professional property managers, if you've got nobody who's interested or people won't pay, my concern is that the standard of these buildings is going to start declining. So we need an effective management committee in place for common hold.
And do you think
freehold, we need the freeholder engaged? Yeah.
Do you think common hold's going to become the new way of doing flats over leasehold? Do you think that's on the horizon?
Again,
or
with no ground rent, where who's going to buy these places, because there's no income stream coming in. So I think there's going to be more and more common hold coming through. And as a lender, I know some don't accept it. We will accept it, but we need to watch how this pans out in the next 10, 20 years in terms of maintenance management of these buildings.
Yeah, that's a really good point. 6.1.1, the loan to the borrower will not be made until all relevant conditions of the mortgage offer, which need to be satisfied before completion, have been complied with and we've received a certificate of title. In 6.1.2, you must check your instructions and ensure there are no discrepancies between them and the title documents and other matters revealed by your investigations. Just on to part 7 now. So if your instructions state the name of a person who is to live at the property, you should ask the borrower before completing the mortgage that the information given by us in our mortgage instructions or mortgage offer about occupants is correct and nobody else is to live at the property. This is quite important for us, and obviously ensuring that we've got our rights as mortgagee on possession. If there's an occupier on the property that we're not aware of, that can affect our rights. So it's quite important for us to be aware of that. You must obtain a signed deed or form of consent for all occupants aged 17 or over whom you're aware who are not party to the mortgage before completion of the mortgage. We recognise that in some cases the information given to us or by the borrower may be incorrect or misleading. If you have any reason to doubt the accuracy of any information disclosed, you should report it to us provided the borrower agrees, but if the borrower does not agree, you should return our instructions. Subject to the below, you must not advise, and so sorry, we're moving on to independent legal advice now, which is also something I'm quite concerned with, because when we start talking about guarantors and people who will be occupying the property who might not be borrowers, for example, it's quite important in us protecting our legal rights. So subject to what I'm about to explain below, generally we say you must not advise any borrower who does not personally benefit from the loan. So that might be a situation where there's a borrower who's not going to be on title, any guarantor or anyone intending to occupy the property who's to execute a consent to the mortgage. But you need to arrange for them to seek independent legal advice or make that recommendation before. Independent legal advice may be provided if the solicitor is satisfied there is no conflict of interest and that the document will not be open to legal challenge. Independent legal advice must be provided in the following situations. So it's actually possible to do it in a number of situations because part 2 sort of edits that part 1 rule. So where part of the loan is not for the benefit of all joint borrowers, and so what this is a situation where you've got a borrower who's not going to be on title, for example, then independent legal advice is required for the borrower not benefiting, but only where said part of the loan exceeds £50,000. ILA is also required for any borrower who will not be a proprietor of the subject property. So that's sort of similar. I've given that as an example in the first one, but a similar concept. And ILA is required for individuals opening a Helpful Start account and providing a surety as part of a Barclays Family Springboard proposition. So for those of you who aren't aware of this, we have a product at Barclays called Family Springboard, where a helper contributes an amount of money which is held in a Helpful Start account. Barclays puts a charge over that amount or over that account and uses that as a notional deposit for somebody else to get a mortgage. So it opens up higher LTV lending for those who might not have a deposit available. When advising, you must only do so after recommending in the absence of any other person interested in the transaction that such person obtains independent legal advice. Any advice that you give any of these people must also be given in the absence of any other person interested in the transaction. And you should be particularly careful if the matrimonial home or family home is being charged to secure a business debt. That's generally not going to be relevant for our purposes, but it's an area where there can be a lot of legal risk. Any consent should be signed by the person concerned, and a power of attorney is not acceptable for ILA. Just moving on to talk about the certificate of title. So you should not submit your certificate of title unless it is unqualified or we've authorised you in writing to proceed, notwithstanding any issues you've raised with us. We shall treat the submission by you of the certificate of title as confirmation that the borrower has chosen to proceed with our mortgage offer and as a request for us to release the mortgage advance to you. So our mortgage advances are paid electronically and we require 5 days notice for them to be paid. And then the offer documentation will state what deductions are required. You're only authorised to release the loan when you hold sufficient funds to complete the purchase of the property and pay all stamp duty, land tax and registration fees to perfect the security as first legal mortgage, or if you do not have them, you accept responsibility to pay them yourself. Before releasing the loan when the borrower is purchasing the property, you must either hold a properly completed and executed stamp duty land tax form, or you must hold appropriate authority from the borrower allowing you to file the necessary stamp duty land tax returns on completion. You must ensure that all stamp duty land tax returns are completed and submitted to allow registration of the charge to take place in the priority period afforded by the search. You must hold the loan on trust for us until completion. If completion is delayed, you must return it to us electronically within 48 hours to the account specified in Part 2. If after you've requested the mortgage advance, completion is delayed, you must contact us immediately and make us aware of that. And then the mortgage advance can be held for 48 hours. So if there's a delay or anything's going to go longer than that, it needs to be returned to us. And if we don't receive it within 48 hours, we do have the right to charge interest. If the mortgage advance is not returned, we will just assume that the deal has been completed and we will charge the borrower interest under the mortgage. Just some points about the mortgage terms and conditions. So the mortgage incorporates our current mortgage conditions and, where applicable, loan conditions. If the mortgage condition booklet is supplied to you with your instructions, you must give it to the borrower before completion of the mortgage. I think the way that this works is that we actually provide that terms and conditions booklet to the borrower ourselves. Let me know if that's not correct, but that's what I've been told. You should explain to each borrower and any other person signing or executing a document his responsibilities and liabilities under the documents referred to above, and any documents he's required to sign. So we'd obviously expect that would happen in your duty to the borrower. Except where we specify otherwise in our individual instructions, the signature of a document that needs to be witnessed must be witnessed by an independent person. The witness's signature must clearly record the witnessing of the signing of the document by the individual concerned, and the name of the address of the witness must appear in legible form. All documents required at completion must be dated with the date of completion of the loan. Once again, you must register our mortgage as first legal charge at the land registry. Our mortgage conditions and mortgage deed have been deposited at the land registry. That's true, and so it's not necessary to submit a copy of them. The application for registration must be received by the land registry during the priority period afforded by the subsisting land registry or land charges search at the time of completion. We do not require the original mortgage deed, but ask you retain a copy on your file, and you may use any available land registry process for registration, including electronic registration. I'm not actually 100% sure where we are up to on this. I know that we do allow for some firms to undertake electronic registration for us. But I don't think that that's something that we're doing on a large scale basis yet. You should retain any original documents until you're satisfied that registration is complete, and you are not otherwise required by us to retain any original documents. All title deeds, official copies of the register, searches, inquiries, consents and requisitions and documents relating to the property in your possession must be held to our order pending completion of the retainer, and you must not create any or exercise any lien over them. If registration at the land registry has been completed within 3 months of completion, you must advise us in writing with a copy of any correspondence with the land registry explaining the delay. After completion, you must only send us the title information documents. For evidential purposes, you must keep your file for at least 6 years from the date of the mortgage before destroying it. You should retain on file these documents as specified in these instructions and our individual instructions, and any other documents which are reasonably competent solicitor or surveyor or conveyancer would keep. Microfiching, data imaging, or material held electronically, constitutes suitable compliance with this requirement. It is the practice of some fraudsters to demand the conveyancing file on completion in order to destroy evidence that may later be used against them, and it's important to retain these documents to protect the bank's interests. Subject to any right or lien or any overriding duty of confidentiality, you should treat documents comprising your file as if they are jointly owned by the borrower and us, and you should not part with them without the consent of both parties. You should on request supply certified copies of documents on the file or a certified copy of the microfiche to either the borrower or us, and may make a reasonable charge for copying and certification. So that's a very quick recap of part one. There's a lot in there, and obviously there's a lot that we expect our panel solicitors to do, but that's just sort of a summary. Just touching on part two quickly, so some Barclays specific requirements. We've just got a few of these which I'll go to. Just on 4.1, the valuation report will only be provided where the property is being purchased using a special scheme like Help to Buy, and the scheme provider provides a copy of the valuation report. Fiona, do you have any comments on that? Is there anything of relevance there for you?
Well, we don't generally release our valuation reports. We're very clear that the valuation report is for us, not for our purchaser. I'm a great advocate of that because in the many years I've been a surveyor, that confusion between a survey and evaluation has been out there. And mortgage advisors and estate agents will talk about you having your survey done. Well, of course, it's not a survey. And to my mind, if the customer doesn't see the mortgage valuation, that reinforces the message that they need to go out and get their own advice. But it's a really key thing. You know, people are buying a property, they can't rely on a mortgage valuation. It's not going to give them the information they want. So we don't tend to release it. There are certain circumstances we do. But even in those many of those occasions, the lawyer, your conveyancer yourselves might get to see it, but it mustn't be passed on to the customer. That information is for the bank only. Things like Help to Buy,
insurance for both purchases and remortgage applications. Sorry, Fiona.
Sorry, go on.
No, you were going to say back Help to Buy?
It's critical that they have a copy of the valuation Help to Buy, so we have made an exception there, but again, not for the customer.
Can everybody hear me? I feel like I might have dropped out.
I think you froze and dropped out, and we've lost the shared screen, Chris.
Yeah, we have. I was just going to say.
Sorry about that. Let me just try and get that back. Can you see my screen now or not?
No. Do you want me to share? Because I'm about to. Oh, yeah, we've got something now, have we? No. Yeah.
Is that visible now?
That's better, but you'll need to scroll through.
Yeah.
Okay, sorry about that, everybody. Looks like my internet just had a little bip. Here we are, back to part 2. Barclays accepts search insurance for both purchases and remortgage applications, provided adequate cover is arranged at the conveyancer's own risk. 5.7.1b, freehold flats and masonettes are not considered suitable as security for mortgages. So I think that's a reference to freehold flats in England and Wales rather than in Scotland. Leases with a minimum of 70 years at commencement should be declined, subject to some specific scenarios.
Just to say on that one, that's actually a fairly recent policy change for those who've done work for us for years. So just to point that one out, because previously we were more lenient on that.
And then leases with greater than 70 years but fewer than 85 remaining must be referred to Barclays for consideration. There are some once again, sort of fairly lengthy provisions on leases, which I won't go into here. I think this is probably quite important, Fiona, given you're going to talk about the EWS form, but if you're on receipt of an EWS1 form, please forward it to Barclays if the form indicates a rating of A3 or B2. And we do not, obviously, it's quite important for us to know.
We really don't want it otherwise. So if the surveyor doesn't ask, or the valuer doesn't ask for an EWS1 form, and you get one sent through to you, and it's not an A3 or a B2, which means that there's no work required, please don't send it through, because all it does is cause post-valuation queries and mayhem and chaos. Because we don't, it's not been asked for by the surveyor, we don't need it, and there's no work required, so we just need to go ahead. So don't just send it through automatically.
6.4.4, financial incentives greater than 5% of the full purchase price or valuation need to be reported, but certain non-financial incentives such as white goods and other goods do not need to be reported to us. I mentioned at the beginning that obviously UKF's looking at amending the handbook. So that working group has been convened and we're joining it next week. So there should be in the future some changes coming. Some of the issues that UKF are looking at are acceptable forms of ID and digital ID, the use of electronic and digital signatures, leasehold issues, estate rent charges, EPCs, and environment and climate requirements, including retrofitting, planning, building safety, and an update of regulators and codes of conduct and register of overseas companies. So you can expect, I'm not quite sure how long it might take, but this has obviously been looked at and there'll be some changes made in the future. Just as a separate issue, one of the big issues that we are tackling at Barclays at the moment is climate risk. The PRA has basically said to us that we need to take climate risk into account in our business model. Us as a bank have made a commitment to be net zero by 2050. And so we are starting to see that come down into the mortgages world. An example of that is our green mortgage product, in which it's only available to people who are buying new build properties with an EPC rating of A and B. And so I think in the future, it's probably not unrealistic to expect that perhaps there might be a role for solicitors to play in that environmental concern of Barclays and other lenders as well.
I think that's a reasonable assumption. Yeah.
Yeah, although we don't know how that will look yet, because this is an area which is obviously developing and fairly fast moving. I'm just going to touch very quickly on dual representation, and then I'll hand over to Fiona. So, I mean, it's just a good reminder that when you are acting for Barclays and the customer, you are acting for two different people. And obviously that can, in some situations, give rise to a conflict of interest. As an example of that might be where you're connected to the seller, for example. In most situations, because obviously Barclays and the customer both have that shared interest in getting the loan completed, it obviously becomes acceptable for the dual representation model to work. But just as a reminder, you cannot act for a client if there is a conflict of interest under the SRA Code of Conduct for solicitors and the Code of Conduct for conveyancers. The risk of, and so under the SRA guidance on this, the conflict becomes higher if the mortgage is not a standard mortgage and you do not use the approved certificate of title. Under the SRA rules, a standard mortgage, a buy-to-let mortgage is not a standard mortgage. And for that reason, it might be a bit more prudent on you to make some more inquiries if you're acting for a buy-to-let customer. Other circumstances that can give rise to a conflict of interest include a financial interest of yours or someone else close to you, or a personal or business relationship of yours. And the risk of conflict is potentially high for buy-to-let. And yes, you may want to take a more cautious approach with those. Very quickly, just some pain points and tips for resolution. I think Fiona and I made this fairly clear in that, you know, when you are acting for us, if you could let us know as soon as possible if you're encountering issues. So if you avoid last minute requests and get in touch with us as soon as you flag something. And if you can avoid sending a large number of documents for us to sift through, that can be a little bit difficult for us. And just remember your obligations under 2.3. So that is to really, you know, note what the issue is, flag the part of the lender's handbook that it's not addressed by, and explain the legal risk to us. If we can get that, it will make things a lot easier for us. And remember to provide the certificate of title only once you're satisfied there are no outstanding matters. And we require obviously 5 days business notice in order to pay. And if you could just keep your firm's details up to date on Lender Exchange, because we do from time to time sort of encounter issues which require us to get in touch with our firms, that would make it much easier for us as well. So. Cool. Now we're on to Fiona to talk about EWS1 forms.
Before we do, actually, there is a quick question, which is probably a good one to answer right now. And Julie asks us, what does at conveyancer's own risk actually mean?
What was that in the, now going back, that was in the context of providing finding insurance, wasn't it?
Yeah. 544. I can't see 546.
No, I can't see it either. Don't know if it was in there. Let me see if I can find it.
Ask a bit more.
I can. Yeah, I mean, I can give a general answer, and I think that's if we're talking about the context of arranging insurance, for example. I suppose that if there was for some reason, you know, that insurance wasn't appropriate. Or it wasn't the right thing to do to organise that insurance, if we're talking about like a title issue, for example. I guess the point there at the conveyancer's own risk is that if it's arranged inappropriately or not done in the correct way, then there may be some liability for that conveyancer, either from us or from the borrower. And so it's important to remember to take those steps carefully. So because if there was... Okay, what was... Sorry?
It was under UK Finance Lenders Handbook recap of Part 2, slide 19. So 546. Barclays accepts search insurance for both purchases and remortgage applications, provided adequate cover is arranged at the conveyancer's own risk.
Yeah, so I suppose the point here is that the conveyancer is responsible for organising that insurance. and if there was an issue with the insurance, there might be some liability that's held either to Barclays or to the customer, and so it's important for that conveyancer to be prudent in organising that insurance. Does that make sense?
Hopefully
it's not it's not a threat or anything like that. It's just that obviously when you're acting for us, we expect that the insurance organised will be appropriate.
So she's come back saying, so you're not underwriting, basically, question mark.
Yes, correct. Yeah, that's right. That's not our business. So was there another question, Fiona, or?
No, that's it. Yeah.
Okay, perfect. Thank you for the question, Julie. Perfect. So we'll move on to talking about
EWS ones. We've already touched on EWS ones. So I'm going to have to ask you to go forward because you've got the...
Yeah. Just let me know when you want me to move slides, and I'll.
Hopefully, those of you who do deal with, particularly those of you who are in the London area where there's a lot of this, are familiar with the EWS1 form, which is here. What we're looking for, there are certain things we're looking for. We don't want the form to be changed at all. We're looking for the form in England. Scotland's different, but we're not talking to a Scottish group here. In England, it needs to cover the whole building. And there are different requirements depending on what the category is, on who can sign it. So if it's a category B1 or B2, the qualification requirements are higher. So EWS1 forms, it's really critical that we get them through when it's an A3 or a B2. But as I said before, if it's not been asked for, don't send it through if no work's required, because it just creates additional work for us and causes delays. So if you go on to the next slide. Are you there? Yeah, that's right. So Barclays in particular, and I know there's a couple of other lenders do this, but not all. We only accept EWS1 forms with a letter of provenance with it. This was a requirement by our fraud team just to set the bar a little bit higher in terms of fabricating EWS1 forms, and we're all familiar with the fact that there's already been one very high profile case where EWS1 forms have been fabricated. This is a huge impact. Fire safety works are a huge impact on the value of the property and the ability to sell. So the incentive to fabricate and fraudulently produce a form is quite high. So we need that letter of provenance on headed note paper, or we won't accept an EWS1 form. So if it comes in on its own without the form with it, signed by the same person, headed and confirming that they've got the relevant qualifications, then you need to go back to your client and ask for them to send that or arrange for that letter of provenance. Hopefully the need for EWS1 forms will start diminishing as the market opens up and buildings get remediated, but it's still quite a big issue for us within the industry at the moment. So, okay, if you want to move on, we'll look at warranties and new build, because this is one that seems to come across my desk an awful lot. Challenges around this. So you've got a new build property and we've got a warranty that's provided. If it's NHBC, happy days, we go ahead and we lend. Where we start hitting problems is where there is no warranty or professional consultant certificate, or where the warranty provider is not on our list of approved providers. So when a warranty provider asks to go on the list, we'll go through a whole process of reviewing them and measuring them against other warranty providers and checking that their provision is acceptable to us. And one of our requirements is that the property must have been inspected by the warranty provider or the consultant certificate provider at various stages from the beginning of construction to completion. So as a consequence, we don't accept retrospective warranties, but increasingly out there, we're getting more and more retrospective warranties. And professional consultant certificates. So familiarity with the UK Finance Lenders Handbook section on professional consultant certificate is really, really important. If you can move on, Chris, to the next slide. It gives you an example of a professional consultant certificate. Warranties are different, but if you've got a professional consultant certificate come through, can you please check that the wording is absolutely correct? Because there is a very standard set of wording that is provided by the UK Finance, and it says things like, I have visited the site at appropriate periods from commencement of construction. So it makes it very clear that the professional consultant certificate provider has been a part of the development all the way through. If you go on to the next slide, you'll see one that we've had through fairly recently, which was sent through by the conveyancer, which said, I've visited the site at appropriate periods from the commencement of my involvement to the current stage. And that's a big red flag. When they start changing the wording because they weren't there at the beginning, it's a retrospective warranty. So we need that alerted to us. So that's one of the ones that just keeps cropping up. The surveyor advises us as a PCC, a professional consultant certificate provided, and when we actually get to see it, we realize it's retrospective. So look out for those red flags. I think on this one there was another one as well, yeah, where in the section, the certification section, they changed it from I visited the site at appropriate periods. Where is it? Difference in point 3. So I certify that I have visited the site at commencement of involvement, again, another red flag. And as so far as could be determined by each periodic visual inspection following inspection and approval of foundations to client, the property has been generally constructed and so far and so forth. And again, they've taken out a section of the wording to fit with the fact that this is a retrospective warranty. So just look at those documents really carefully, measure them up against the standard PCC, and please alert us if they start changing the wording, because we need to review those. We don't want retrospective warranties. I'm just looking at the time. How are we doing? It's half past. I've got some
we're at
examples.
half past.
Yeah, I've got some examples. We don't need to go through them because we've hit time. But, you know, just pointing out Hart and Large, where recent case law, both the conveyancer and the surveyor were found to be at fault for not advising the client around professional consultant certificates. So we've got recent case law. Familiarise yourself with it. It's really important that where you've got a new build or where you've got a major structural works, almost a rebuild, and there was just a few examples that I'd got there. Make sure that it's adequately covered.
No, it's a fancy looking house, that one, gosh.
Yeah, that one, if you go on to the next slide, it'll show you what it was before. Oh no, the one before.
Okay.
No, that's
that's it, is it? Yeah,
that's it before and further up.
Okay.
Yeah. So that's an example of the sort of thing we'll get. I haven't got time to go through them now. The key message here is make sure that those documents don't have their wording changed to suggest that the provider of the warranty or the consultant certificate was not involved in the build process. Yeah. Have we got any other questions? I can see.
Yeah, any other questions?
Doesn't look like it, does it?
I can see, hang on, there's...
If you can see 4, we've dealt with it.
We've dealt with those, yeah.
Okay, fantastic, cool. I just came off screen share so I could see them better.
I think a link will be sent to all the members of the recording of the session. So, you know, looking back over it might prompt further questions, which I believe they can get in touch with somebody to answer a bit further down the line. Is that right?
Yeah, that's fine by me. No problems at all.
Yeah. I got to say, I found that really interesting from being on sort of the environmental risk side of things, and very much interested in climate change. It was good to see that lenders are looking at climate risk and what that means in the conveyancing process. It'll be interesting to see how that progresses, which I think it all will. Seems to be, as you said, hitting us all and impacting in lots of different ways. So it's good to hear that. Okay, well, if there's any more questions, thank you everybody for joining the session today. From Landmark's perspective, I found it really, really interesting. Thank you, Fiona and Christopher, for some interesting points on what could be quite dull looking through through all of that. Oh gosh, I can't believe how much solicitors actually have to take on board. So well done, everybody. Okay, and thank you very much, everybody.